So you must have heard that the Court of Appeal has refused to reduce Lucy Connolly's 31-month prison sentence. Now, I can sit here and tell you in a technical sense why the court ruled the way that it did, and in a technical, boring, dry legal sense, that makes some kind of sense. But what it doesn't do is reflect the reality, I think, of what the vast majority of people think. Now, the caveat, some people online are pleased with it and they think that it's the right decision, but the vast majority of people that I've seen online say that this is wrong. She shouldn't be spending 2.5 years in prison for a single tweet, which she clearly regrets. And whilst everybody agrees that the tweet was wrong and shouldn't be said and you shouldn't say those things and all of that, it's just wrong that someone spends 2.5 years in prison for a single tweet. Now, I have a few thoughts on this. Now, this is going to be slightly different than my usual take on these things because I will refer you to bits of the judgment. I will refer you to the bits of the sentencing guidelines, etc. But what I'm going to talk about really is this is, in my view, the best example of what I like to call system and reality. I've referred to this for many years now, system and reality being the system being, this is how the system works, this is what it does, these are the rules, these are the laws, and this is what happens, and this is the way it moves forward, and this is how it all works. The reality is, it just doesn't reflect, I think, what the vast majority of people think is right and fair. And given that it is a justice system, and inherent within a justice system, it should be fair, I don't think people accept this. And I think this really defines this country in not a very good way. Now, this has obviously caused quite a bit of stir. I'll refer you to a few posts here. There's one from Free Speech Union. There's one from Rupert Lowe. It's all over GB News, etc. Free Speech Union says, we're deeply disappointed by this judgment. No one disputes the tweet was offensive, but the sentence of more than 2.5 years is plainly disproportionate. Again, there's a boring technical legal reason why it isn't, but that's not me saying that I agree that it's right, and it's not me saying that I agree she should spend 2.5 years in prison for one tweet. I don't, as it happens. Personal opinion alert, don't shoot me. I just don't think she should be spending 2.5 years in prison for a single tweet, however heinous and horrible the tweet was. Do I agree that it was wrong? Yes. Do I agree that people shouldn't say those things? Yes, with the caveat that we do have free speech up to the point of a criminal threshold. But do I think that that criminal threshold and this sentence is proportionate to one tweet? No, I don't. That's my personal opinion. I think it's a bit ridiculous. But here we are. They say Lucy should be at home with her family, not locked up in jail, while her husband, Ray, battles bone marrow failure and her 12-year-old daughter struggles to cope without her mother. And of course, you can see further details in their article. Now, again, just an emphasis. This is a classic case of what I like to call system and reality. The system says, for reasons I'll show you in a minute, the system says that she's to stay there because of the reasons the court has given, and based on all the rules, based on all the laws and all the procedures and everything else, the court has said this is the right decision. The reality is, I think the vast majority of people think this is just a bit ridiculous. With great respect, I'm not criticizing the court in this sense. I'm just saying that I think that the system that has led to this situation here is ridiculous. This bit is the primary point of the judgment here, that I think this is talking to one of the grounds of appeal. There were two grounds, essentially. One, attacking the actual plea and that she didn't really realize what it was and the legal advice was not appropriate, etc. And the lawyer at the time was cross-examined on that point. And secondly, there was a ground about mitigation. Both were refused, and so the sentence stayed as it was. The principal point here, this is on the first of those grounds, was where apparently she signed this declaration here, which said, I, Lucy Connolly, date of birth, confirm that I do not wish to enter a basis of plea. And I'll explain that in a minute. And I understand that this means I'm conceding that at the point I published the tweet, I intended to incite as per the Category 1 feature. It transpires this was supposed to be the 1A, but more about that again in a minute. It says, I do this as I do not believe I will be successful at a Newton hearing. A Newton hearing is a mini trial within a trial, so a trial of the issues. Again, I'll explain it in a minute. And it goes on, I do not want to risk my credit. You get credit for an early guilty plea. This is my decision, under no pressure from anyone else. I know, therefore, that this will be a Category 1A offence with a starting point of 3 years imprisonment. Now, just to unravel and unpack and explain that a little bit in the boring legal detail, this was saying that she doesn't wish to enter a basis of plea. So when you're charged with something and you're prosecuted, You can either say, yes, guilty as charged is the phrase, well, the common phrase, which means you are guilty as the charge sheet says. It means that you admit everything they say you did in the circumstances that you did it, and so on. However, and I've done this in the few cases that I've done in the criminal courts, I've done this with clients before now, where it's, well, my client says, yes, I did it, but there's a very good reason I did it. They were threatening my family. They were, putting pressure on me. They were threatening me. I had no choice, whatever. There's a basis of plea that is possible sometimes. So the basis of plea could be, yes, I admit that I did it, but here's the reasons and the wherefores that I did it. And so they explain the basis of the plea. Now, if that's accepted by the prosecution, now, usually when I've done those, they are accepted by prosecution counsel. We go back and forth and they say, yeah, okay, we'll agree that. We agree the wording. I agree the wording with the client. They agree the wording on behalf of the prosecution. And we put that forward as a basis of plea. Of course, then the court needs to accept it, but the court will usually accept it. But it's still down to the court. But if it's not accepted, if the prosecution do not accept a basis of plea, then you have a mini trial only on that one little issue. And it's called a Newton hearing. It's a trial within a trial. So it's a trial of that particular issue. And so what they were saying here is this declaration that she signed said that she didn't think she'd be successful at a Newton hearing, i.e. The basis of plea, and didn't want to risk credit. So just to be clear, if they did have that Newton hearing and she did put forward a basis of plea and said, well, I do admit it, but on this basis, and the prosecution didn't accept it, and then they had a mini trial, if she was successful, she would retain all of the credit for pleading guilty. If not, she might lose some or all of it. So this was one of the principal reasons throughout this on the first ground that the judge didn't accept this ground of appeal. And there were further submissions to the court on the basis that counsel contended that the words of the tweet could not be read as serious incitement to burn buildings with people inside or to kill politicians, submitting that on the evidence it was never made clear to Lucy Connolly precisely what concession was being made on her behalf, and further argued that the judge should have questioned her culpability, whether it truly fell into category A. The short version is the court didn't accept that, but just to explain the category A bit here, this is where we come into the sentencing guidelines. Category A is on the culpability. So if it's accepted, and indeed it was here because the court upheld that, if it's accepted here that the person had the intention to incite serious violence, then it falls into category A. And the category 1 bit is simply that whatever the publication was directly encouraged the activity which threatened or endangered life. So in this case, the judge essentially said that because she signed that declaration, the judge didn't accept any argument or contention that she didn't really mean that and didn't really intend to incite the serious violence to get people to burn buildings. So, but that's, again, system and reality. The system says she signed this thing and her legal advisor supposedly advised her what this meant, and she signed it, and the court said that we are unable to accept the argument that on a close textual analysis of the offending tweet, that this leads to a conclusion that there was no more than an expression of emotion which could not be taken seriously. So it was argued on her behalf that this was just an angry tweet. It was an expression of emotions. With everything that had happened in her life and with everything going on in the country, she was just airing frustration. She was just showing how annoyed and frustrated she was, and that it wasn't a serious incitement to violence. She wasn't really saying, you lot go and do this thing, go and burn the buildings, etc. The argument was that she was not doing that. And that could be interpreted as the reality in my analogy of system and reality. The system says that she did agree to that she did agree that's what she was doing. The reality is what I think a lot of people think, and what I genuinely think, really. I don't think, if you really come down to it, and I know I'm departing from what the court says here, I mean this respectfully, so there are only really two possibilities. Either, as the system would have it here, that she did really genuinely deep down, she did intend to incite other people to go and burn buildings with people in it and therefore cause serious violence and harm. Either she really did intend to incite that, or she didn't. And now this is a really subjective viewpoint here. I just don't think she did. Even if it was explained to her, even if she did sign the thing, even if this has now led the court to say that the words, we're reading from this bit in here, the middle bit in yellow at the end here, the words of the tweet are on their face an incitement to serious violence. Well, yes, if you read it word for word, without any emotion, without any real deep down human understanding, yes, on their face, they are an incitement to serious violence. I think we all accept that. I think we all accept that this was wrong. And then the court rightly said it's important not to lose sight of the fact that she willingly pleaded guilty and she signed that declaration and so on. But that doesn't break this system and reality theory of mine that I think does hold true. On the system side, she was told, she signed it, and the rules say this, and the sentencing guidelines, I mean, I'll come back to the sentencing guidelines and where they start. If we look at the maximum sentence for this is 7 years, and for a category 1A, the starting point is 3 years custody, with a range of 2 to 6 years, and you take in the aggravating and the mitigating factors, etc. On the system, on the face of it, it was right. But the reality, I just don't think accords with what people really think. Now, without getting inside Lucy Connolly's head, I can't tell you precisely what she thinks. Deep down in there somewhere, did she really think that? I don't think that's the case. Let me know in the comments if you think she really intended to incite people, as in genuinely she really wanted her tweet to make people go and burn the buildings. I just don't think that's the case. But on the face of it, on the system, on the documents, on the law, on the sentencing guidelines, on the declaration that she signed and everything else, the court drew the analysis that, quote, in those circumstances, we are quite unable to accept that she signed the endorsement without any understanding of its references to the culpability factor or the starting point. We are also unable to accept that her state of ignorance in that regard continued throughout further conferences with Mr. Muir, or that she entered guilty with no understanding of what it entailed. Her acceptance that she read and was content with Mr. Muir's sentencing note, which includes references to the sentencing guideline and to the aggravating feature specifically mentioned in the guideline, clearly shows that she was well aware of what she was admitting. It follows that we reject the applicant's evidence on which ground 1 depends, and ground 1 is unarguable. And as to ground 2, this was the aggravating and mitigating circumstances. Those were her personal circumstances. The court just summarised very briefly, and in short, the court said that the judge was entitled to conclude that the serious aggravating factors, obviously about what was going on at the time, outweighed the mitigating factors, and therefore ground 2 didn't succeed, and therefore the sentence wasn't reduced. So on paper, systematically, legally and technically, that's why the court ruled this way. I do this video in the hopes that it helps somebody to understand that this is technically why it happened, but also just some reassurance that I think there's a lot of lawyers that won't agree with this. I think a lot of lawyers will not agree that 2.5 years in prison for one tweet is right for a society. As wrong as the tweet was, and as much as we can all agree that she shouldn't post those things and people shouldn't post those things, I think this is a case that shows system versus reality, and the reality is a lot of people don't accept it. And so comparing that, for example, with this case here, where we have former Labour MP Mike Amesbury talking about one mistake that he made, which you'll remember he was initially given a 10-week prison sentence for repeatedly punching somebody, physically punching somebody, and then on appeal that was suspended for 2 years. I'm reminded of my own comment where I quote posted this and said, humility is commendable and takes courage, because he was admitting to his mistake here. But Lucy Connolly also made one mistake and didn't lay a hand on anyone. She should not still be in prison. So that was just my view here. And I linked a video here talking about sentences and things like that, where victims genuinely don't think that the punishment fits the crime, where the offender gets a very, very low sentence in many cases. I'll link that video below. You can go and watch that. That was partnered with Five for one of their TV programs. But also Rupert Lowe has put pen to paper here to the Justice Secretary and said, I understand that Lucy Connolly has made an unpleasant remark on social media. It was a foolish thing to post, as she soon understood and rapidly deleted. Can you honestly say that having a young mother behind bars is an efficient use of prison punishment? I certainly can't. Who is being served by having Lucy Connolly in prison? It is definitely not the public, who I believe would feel far safer if a violent criminal was incarcerated in that cell, bearing in mind there's fewer than 1,000 places left and tens of thousands of cases in the backlog. Rupert Lowe says it is morally repugnant to separate a mother from her children over one stupid social media post, soon deleted. It is not just Lucy, there are others currently in prison for similar. Is this really what the British justice system should be prioritising? Is this what the British people want? Is it fair and just? The answer to all of those questions is a resounding no. Logic must prevail and Lucy Connolly must be allowed to go home. And that was Rupert Lowe MP. Let me know in the comments what you think below. As I said at the outset, I can tell you in a boring, dry legal sense why this makes legal sense on the system of the rules and the sentencing guidelines and the document she signed and everything else. I can tell you all of that. That's the system. And in my view, the reality is starkly different. I think a lot of people think this is disproportionate and wrong. But that's my view. You may not agree with me, and that's perfectly fine. Let me know in the comments if you disagree with that and you think it's absolutely right that she should remain in prison. Equally, let me know if you think this is heinous and she should be allowed to go home. Let me know what you think. Please do remember to like the video and subscribe for these honest views on these things. This is a rare subjective viewpoint of mine on this video, but I have tried to explain technically why it happened. So for that, thank you for watching, and I'll see you next time.